Joining us now, the author of the controversial torture memos written under President Bush, former U.S. Deputy Assistant Attorney General John Yoo.
Welcome, Mr. Yoo. President Bush recently was asked about torture and waterboarding, and he essentially said, well, look, the lawyers told me it was legal.
Why is waterboarding legal, in your opinion?
Because the lawyer said it was legal. It said it did not fall within the Anti-Torture Act. I'm not a lawyer, but you got to trust the judgment of people around you, and I do.
You say it's legal, and the lawyers told me.
Yeah.
And I guess he was probably pointing to you in that case, and I wonder if you feel that he's walked away from you.
Look, I do. Part of the job of being a lawyer is defending sometimes unpopular decisions that your clients make, and I'm willing to do that part of the job.
The warning from the mayor of London to former President Bush: do not come to Great Britain because we may have to arrest you for torture, just as we did General Pinochet.
Okay, let me back up because I'm a little bit confused. As I understand it, okay, so torture is not allowed. Confessions derived from torture are not allowed in court.
Period.
And yet, Mr. Yoo came up with a definition of torture, or a new definition that said this is not torture. So why wouldn't it be allowed if the confession were from something that isn't legally torture based on their definition?
Well, John Yoo, respectfully, is a widely despised figure in the legal profession because of that torture memo. Because he said anything that isn't tantamount to organ failure is not torture. So, for example, waterboarding to Mr. Yoo is not torture. That view, I think it is safe to say, has been repudiated by virtually every legitimate law expert in the world, not just the country. So his view on what constitutes torture, I would say, is somewhat unique.
So how did he come up with this definition? What's the difference between, for example, enhanced interrogation techniques and torture as he described? You say the organ failure thing, but based on what? I mean, what was the original definition he used?
Well, they got the definition actually out of a treaty that we signed, where we promised that we wouldn't torture people. And then Congress passed a law with language exactly mapping the language of the treaty. And it said cruel or inhumane treatment counted as torture. So you can just find that for yourself. He didn't have an exact analog anywhere in American law, so he looked to a healthcare statute and said that that was a basis for figuring out what counted as prolonged pain and suffering. And the healthcare statute pertained to what? It pertained to the compensation of hospitals under certain conditions of emergency room treatment.
So
nothing to do, bottom line, nothing to do with torture.
Right. So it's fair to say that John Yoo's interpretation of both what torture is and its torture's place in our legal structure has been abandoned universally by other than a small fringe of the legal community.
Including by the Bush administration.
Correct.
This isn't like the radical crazy liberals in the Obama administration. These are his successors in the Justice Department under Alberto Gonzales and under Michael Mukasey.